The Trump administration's approach, inherited from Silicon Valley of move fast and break things, may be able to go unchecked in the business sector. However, when done in government, there can be certain legal hurdles to account for. Already, there are many suits being brought in federal and state courts to challenge some of the White House's actions, much of which involve the canceling of funding opportunities or workforce reductions. It begs the question, can the judicial branch handle this new workload that will come from settling these disputes and making sure their decisions are respected? For some perspective on this, we welcome Richard Pierce, a law professor with George Washington University. Professor Pierce, thank you so much for taking the time.
It's my pleasure.
So, front and center, what are your thoughts when you see, whether you agree or disagree with the actions taken by the administration, when you see lawsuits popping up one by one and you're seeing judges almost being hamstrung to come up with a decision of a very complex legal issue within a week? I mean, does that just make your hands sweat? What's your reaction?
Yes, it does. I mean, I actually feel very sorry for the judges and now for the justices of the Supreme Court. There are at least 50 or 60 really important constitutional issues that already have been raised by the Trump administration actions in the first few weeks spent in office. Each of those should be the subject of lengthy briefing and oral argument and research, first at the district court level and then at the circuit court level and then finally in the Supreme Court. And that process takes, at least 3 to 5 years. And that's impossible in these circumstances because the facts on the ground are changing far more rapidly than the normal judicial pace of decision-making can handle. That means that virtually everything is going to be resolved on what is theoretically a temporary basis, but may well turn out to be a permanent basis through the issuance of injunctions and then the appeal of those injunctions to circuit courts, and then the requests, the motions to overturn them on the Supreme Court's emergency docket. And I think the Supreme Court, it has one before it right now. It undoubtedly will have scores of emergency motions before it in the next couple of months. And the court is going to have to make a whole lot of decisions in circumstances in which no court should be pressed to make a decision. In circumstances in which there's very little briefing, no oral argument, and in most cases, probably no opinion issued by the court. So what we're going to get eventually is a string of yeses or nos with no majority opinion, perhaps occasional dissenting opinions or concurring opinions. And that's a horrible way to do business. And I have to say that I think some of these issues are relatively easy to resolve against the administration. Some are relatively easy to resolve in favor of the administration. There are many that are simply important, unprecedented decisions that will have to be made in these unfortunately high-pressured, no time for deliberation circumstances.
We're speaking with Professor Richard Pierce from George Washington University. And yeah, with those emergency injunctions, it almost makes the courts sound like a voting body where all you're getting is yes or no decisions. And that's not what the role was meant for the judicial branch. What can you say to how this speaks to how folks now view the judicial branch? Because whether the decisions come out, they're either lambasted against or cheered on. This isn't where judges like to be, right? They don't like to enter the political sphere like this.
No, absolutely not. And it's unfortunate that they're being put in the political sphere. And you've got arguably the most powerful, or certainly the second most powerful person in the United States, arguing that they should all be impeached if they decide against the administration. That is not a good way to make decision. It's as you know, the Supreme Court was already at its lowest level of popularity in modern history. I think the entire judiciary has its reputation at stake very much in what unfolds over the next few weeks. And in a sense, it's in a no-win situation because it will incur the wrath of a high proportion of the citizens of the country no matter how it resolves these, what are going to be 20 or 30 major disputes.
Let's talk the actual physical manpower of the courts. I mean, these judges, they don't do it alone, right? You need the court reporters. You need the clerks to help them look up and dive into these legal issues. Is that workforce being stretched thin as well, just like the courts? And do they have the support they need, and do they need more to actually help get this done?
Well, even without the unusual circumstances that they've been pressed into by the Trump administration, they were already in trouble. There was an emergency bill that was enacted by the House and the Senate at the very end of the Biden administration that would have added 60 judgeships. Those judgeships are desperately needed in order to provide sufficient resources to the judicial branch just to handle normal circumstances. Unfortunately, President Biden vetoed that bill, so we're not going to get that expansion of the judiciary. Ordinarily, 2 or 3 good law clerks and administrative staff is enough to allow a judge to perform his or her duties. They're going to have to be working day and night. And unfortunately, when people are pressed into really, really fast decisions on very, very important issues, they usually make a lot of mistakes. It's really hard to imagine, even independent of the partisan dimension of the problem that they're in, it's hard to imagine how they can come up with high quality decisions. And they certainly don't have the time to write the kind of detailed, carefully reasoned opinions that they ordinarily write. So yes, this is a crisis for the judiciary, and we'll just have to see how well they're able to weather the crisis.
The current injunctions is kind of just another term for legal limbo, right? I mean, does that process need to be analyzed as well for, because a Trump, let's just say any president enacts a policy, it could be illegal, could not be illegal. A judge says, hold off, let's not enforce it until we've had a chance to make a decision. The politics of it deem that it needs to be pushed forward, or there are deadlines set, like with the deferred resignation program. Does the injunction process itself need to be looked at here as a mechanism for not hampering what an administration wants to do, but also giving the judiciary a chance to take a look at it in a full scope of ways, rather than just having to say yes or no?
Well, but before the past election, before Trump became president, there was a lot of controversy among judges and among justices, frankly, about what to do about preliminary injunctions, and that's going to become an even more intense debate over the next few weeks. Frankly, it's very, very hard to resolve those issues as well. Just to illustrate, some judges issue nationwide injunctions, but there are some judges and some justices who think that no district judge should have the power to issue a nationwide injunction, and they think that injunctions should be limited to the parties before the court. And so there's a very lively debate about that among judges, among justices, and among scholars. There's loads and loads of law review articles on each side of that debate. Well, it now has taken on a really interesting tone, because when NIH ordered that the overhead on all of its thousands and thousands of contracts to hospitals and universities had to be cut by more than 50%. That was, of course, the subject of an immediate motion for a preliminary injunction. The motion, understandably, was filed by the attorney generals of the 22 states that are controlled by Democrats. And the judge in that case decided that he didn't have the power to issue a national scope injunction, so he issued an injunction that was limited only to the parties before him. But that produced a totally unacceptable situation in which all the hospitals and universities in Democratic-controlled states got over twice the overhead on all NIH contracts as all of the hospitals and universities in the Republican-controlled states. Now, fortunately, that was overtaken because there was another court